Welcome to this explainer. Okay, today we are diving into a truly mind-bending clash of paradigms. We're going to examine a real-world case where rigid, unyielding judicial mechanics slammed head-on into high-level scientific reasoning. And the kicker? We'll see how 5 major artificial intelligence models objectively analyze the wreckage of this collision. It's a profound intellectual battle, and I am absolutely thrilled to unpack it with you all.
Let's kick things off with a question that honestly sounds like a bizarre thought experiment, but I promise you, it's the very real premise of our source material today. Can a PhD actually be used as legal proof of criminal intent? Like, can being too smart or too highly educated literally be weaponized as proof of guilt in a court of law? Keep this wild idea in the back of your mind, because it is the absolute beating heart of the case we're breaking down today. To unpack all this, we'll be moving through 5 key areas. First, the presumption of guilt. Second, the epistemological defense. Third, the scientific defense. Fourth, the logical defense. And finally, the AI legal consensus. Let's just jump right in.
All right, part 1, the presumption of guilt. Can a PhD really be proof of a crime?
So, here's what happened. Judicial authorities in Kunming convicted a complex systems scientist, Dr. Chen, of picking quarrels, and they did it using a really dangerous 3-step leap in logic. Check this out. Step 1, the defendant has a PhD. Step 2, therefore, he should know how to perfectly distinguish true from false. And step 3, therefore, the mere act of him forwarding a controversial post is absolute proof of malicious criminal intent. They completely bypass the need for objective evidence, essentially weaponizing his own academic identity against him to prove his guilt. Crazy, right?
This creates just a bizarre disconnect. Think about it. The court's logic dictates that having a higher education magically equates to absolute certainty. It literally criminalizes knowledge. But standard legal reality? Well, that dictates that a guilty mind, or mens rea in legal terms, absolutely has to be proven by concrete facts. It can't just be presumed based on how smart someone is. It sets up this terrifying sort of reverse discrimination, where being a scholar is suddenly a massive liability.
Which brings us to part 2, the epistemological defense, or the limits of reason. Now, faced with this kind of logic, Dr. Chen didn't just sit back and deny the charges. No, he built a massively dense, incredibly profound philosophical defense straight from his jail cell. He actually cited Plato's cave and Gödel's incompleteness theorem to argue for what we call epistemic humility. Basically, because human cognition is inherently limited, absolute certainty is just impossible. He couldn't absolutely know a forwarded article was false. He saved and shared it out of natural academic curiosity, not some deep-seated malicious intent.
Moving to part 3, the scientific defense, the actual physics of social media.
Having effectively dismantled the subjective intent argument, Dr. Chen pivoted. He shifted gears into the hard physics of complex networks to tear down the objective charges. The law explicitly required proof that his posts caused severe disorder. But when you look at the topology of a scale-free network, Dr. Chen is what you'd call a peripheral node. He had a tiny audience. So, in the strict realm of physics, his individual action was, literally, just background noise. And he didn't just say this, he proved it mathematically. Using the Galton-Watson branching process, he demonstrated that for a peripheral node like himself, the basic reproduction number, or R0, is strictly less than 1. To put that into perspective, in complex systems, that means the probability of his forwarding causing some massive societal avalanche is exactly 0. The physical outcome the crime required? It was mathematically impossible.
All right, part 4, the logical defense. Reductio ad absurdum.
For the final prong of his defense, the scholar utilized reductio ad absurdum. Basically, taking the court's argument and stretching it to its absolute, absurd, logical conclusion. He pointed out that if collecting, analyzing, and questioning controversial material is a crime, well then the very act of being a scholar is inherently illegal. They weren't just punishing a supposedly malicious act, they were criminalizing the fundamental academic method itself.
Let's just pause for a second and really appreciate the sheer architecture of this defense. On the philosophical dimension, he completely targeted the subjective intent. On the scientific dimension, he took out the objective causation. And on the logical dimension, he struck at the systemic legitimacy of the charge itself. It is a brilliant, totally cross-disciplinary fortress of an argument. But of course, the big question is, how did it actually hold up?
Which leads us to part 5, the AI legal consensus. Let's see how 5 major models evaluated this.
So, the source material actually fed this entire clash into 5 major large language models. We're talking ChatGPT, Copilot, DeepSeek, Gemini, and Grok to get a completely objective analysis. And you know what? The results were staggering. All 5 unanimously concluded that the court's logic was entirely legally invalid. They clearly noted violations of objective imputation, an unfair reliance on presumed guilt, the extremely dangerous replacement of evidentiary rules with simple identity labels, and, importantly, a total lack of factual causation for this alleged severe disorder.
What the AI models observed here was honestly a tragic cognitive mismatch. On one side, you have the scholar, right, presenting this brilliant, systemic defense deeply rooted in math and epistemology. And on the other side, the court, a system that appeared entirely immune to dense rational argument, choosing instead to rely entirely on simplified, authoritative labels to just force a conviction through.
In fact, one of the AI models, DeepSeek, provided this incredibly profound, almost poetic summary of Dr. Chen's defense document. They called it a letter of distress from the frontiers of reason. Wow. The AI noted that while his defense was an absolute intellectual triumph, its tragic flaw was that it spoke a language of logic and science that the judicial machinery just wasn't built, or maybe just wasn't willing to understand.
Which leaves us with a final, pretty provocative thought to ponder. In a society or a system where high intelligence, holding a PhD, and just having a natural academic curiosity are presumed as automatic proof of guilt, what happens to the actual boundaries of rational inquiry? When the very act of seeking to understand complex systems is labeled as a threat, how do we protect the pursuit of knowledge? It's an incredibly delicate balance, and this explainer really forces us to look closely at where those boundaries are being drawn. Thank you so much for joining me today. Keep questioning, keep learning, and I'll catch you next time.